Good afternoon, and welcome to the final round of the 2015-2016 Hale Moot Court Honors Program competition. My name is Cody DeCamp, and I am the chair of this year's program. The Hale Moot Court Honors Program began in 1948 by a group of law students and was named after the then dean of the law school, William Green Hale. Since then, the program has developed into one of the most prestigious honors programs that this school has to offer. At the beginning of this academic year, the Hale Moot Court competition commenced with 40 of the most outstanding advocates from the second-year class. Each student was selected based upon his or her excellent performance, both orally and in writing, during the qualifying rounds at the end of their first year. 16 of the students advanced to the quarterfinal rounds, 8 to the semifinal rounds, and finally, 4 were selected to argue in today's final round. The final round represents the culmination of their dedication, perseverance, and excellence throughout the year. I'm delighted to welcome you here today to support the program and its participants and to celebrate the remarkable achievements of this year's 4 finalists. They are Andrea Hajiani, Patrick O'Connor, Joseph Peacock, and TJ Gill. Please join me in congratulating each of them for their success in the program. At this time, Professor Rasmussen would like to say a few words of welcome.
Good afternoon, everyone. It's great to have everyone here. I would send a big welcome out to you all, but especially I want to welcome and thank the judges that are here with us today. They take time out from their busy schedule to help us continue this event, and I really appreciate that. And I also want to have you please join me in thanking them not only for this, but quite frankly for their service to our state and to our country. So thank you. Now, Cody mentioned that we've been doing this moot court since 1948. What's equally impressive to me, in addition to this long lineage, is the fact of how relevant it remains to the essential skills of a lawyer. So let's think about it, right? We take students after 1 year of law school, and we throw them into areas of law which they have no familiarity whatsoever. We will see they'll talk about the Americans with Disability Act and Batson issues, but they without fear dove in, learned these areas of law. Next, they had to take this knowledge and write a brief. They had to communicate clearly and rigorously both the facts and their arguments. Finally, they had to stand up, articulate their theory of the case, and respond on their feet to sometimes probing questions, sometimes hostile questions, and keep their cool. These traits, right, the fearlessness to learn new areas, the ability to think critically and rigorously, and the flexibility to think on your feet, they're hallmarks of what make us lawyers. So this competition really reminds us of that fact. And finally, I'd like to just make 3 acknowledgments before I turn it back over. First, I'd like to acknowledge this year's Moot Court Board. One of the things that we are proudest of here at USC about this competition is that it's run by students. It's run by students. They take time out of their 3rd year, when a lot of people are at the beach, to put this competition on. It would not be as successful as it is, but for their constant hard work and efforts. And I and the rest of the faculty both admire that and appreciate that. Secondly, I'd like to also acknowledge the tireless work of Professor Lonergan. Professor Lonergan is here, I think, for her 9th year. And during her tenure as assisting the Moot Court program, she has ensured that we continue to increase the level of sophistication, maintain the level of professionalism, and make it a true learning experience for all our students. And finally, I don't know if he's made it here yet or not, I'd like to acknowledge Edward G. Lewis. Mr. Lewis sat where these guys sat, right? He was a member of the class of 1970 and was involved in the Moot Court process then. While he was a student, he helped revitalize the Moot Court program. And through his generosity and support, he is endowed the Edward G. Lewis Champions Prize, the prize that one of these 4 students is going to win today. So, like you, I'm looking forward to a lively and entertaining argument. Thank you.
Good afternoon. My name is Amanda Sardis, and I'm the Administrative Vice Chair of this year's board. This afternoon, the participants will be addressing 2 issues before the United States Supreme Court. 1, does the Americans with Disabilities Act require an employer to automatically reassign a disabled employee to a vacant position of approximately equal pay and status in contravention of that company's best qualified hiring policy? And 2, did the district court err in holding that the use of a peremptory challenge to remove a prospective juror on the basis of that juror's perceived sexual orientation did not violate the Equal Protection Clause? Petitioner Chick-4-Me owns a chain of restaurants that serve unhealthy fast food. Chick-4-Me's owner is notorious for having made anti-gay statements and contributing money to anti-same-sex marriage campaigns. Respondent Amanda Sardis is a 35-year-old woman who has a 4-year business economics degree, but no graduate degree. Sardis worked for Chick-4-Me as a part-time spot checker 1 for 8 years. In that job, she worked 30 hours a week, driving to Chick-4-Me restaurants where she would check if the stores were complying with Chick-4-Me's quality standards. The job involved a great deal of walking and driving. Approximately 6.5 years into her time at Chick-4-Me, Sardis developed a medical condition which made her unable to stand for longer than 15 minutes or drive for longer than 2 hours at a time. Her doctor told her to find a new job. Chick-4-Me's headquarters had 1 vacant full-time position that Sardis was qualified for, Data Analyst 1. Chick-4-Me only had 3 analysts. The analysts generally informally trained one another on the job. The job posting for the analyst position required applicants to have a 4-year degree or equivalent work experience and stated that a graduate degree in a relevant field was highly recommended. The analyst and checker positions are both entry-level positions that require 4-year degrees and both pay $25 per hour. Sardis applied for the analyst position, but another worker, Cody DeCamp, was chosen. According to Chick-4-Me, DeCamp was chosen because he had a master's in statistics and had been working full-time at Chick-4-Me as an analyst assistant for 2 years. Sardis and DeCamp both had consistent above-average reviews from their supervisors. Chick-4-Me has a best qualified hiring policy, which was included in the analyst job posting and is contained in an employee handbook. The policy has been consistently applied for more than 10 years. Per that policy, the best qualified applicant was determined by 1, the length of time at the company, if applicable, 2, the level of education, 3, the applicant's interview, 4, whether the employee is currently part-time or full-time, if applicable, 5, the applicant's reviews, if applicable, and 6, the applicant's resume. After being denied the analyst position, Sardis was offered an administrative assistant position, which was full-time and paid $19 per hour. Sardis refused that job. All of Chick-4-Me's full-time positions provided benefits, but the part-time positions did not. Sardis sued Chick-4-Me, alleging that it violated the Americans with Disabilities Act when it failed to give her the analyst job. The case was set for jury trial. The parties stipulated that Sardis was a qualified individual with a disability and that no other reasonable accommodations existed for her disability. During jury selection, the court questioned the potential jurors. When the court asked about each juror's employment, Juror 5, a male, stated that he was a certified personal trainer, and Juror 8, a female, stated that she was a health and wellness coach. When asked if she was married, Juror 8 referred to her spouse as she. When asked about her hobbies, Juror 8 stated that she volunteered at a community center for LGBT kids. Juror 8 was the only juror whose answers implied she was homosexual. Each party's counsel was allowed to ask questions. Chick-4-Me's counsel asked Jurors 5 and 8 whether they had ever eaten at a Chick-4-Me restaurant. Juror 5 said that he had, but only when it was the only food around. Juror 8 said she had not eaten at a Chick-fil-A restaurant because eating fast food would make her a hypocrite because she tells her clients to eat only healthy foods. When it came time for peremptory challenges, Chick-fil-A's counsel accepted Juror 5, but used his final peremptory challenge to strike Juror 8. Sardis's counsel objected under Batson versus Kentucky, arguing that Chick-fil-A's request to strike Juror 8 was a discriminatory attempt to eliminate the only homosexual juror because she would be biased against Chick-fil-A because of its owner's anti-LGBT activism. Chick-fil-A's counsel argued that he struck Juror 8 because she was a wellness coach who would not be impartial in a case involving a fast food company. He also argued that they did not even know Juror 8's sexuality and that her answer about her spouse was incidental and unprovoked. The court agreed that Chick-fil-A's owner was notorious for being anti-gay, but also found that Chick-fil-A's counsel had asserted a reasonable, non-discriminatory concern about Juror 8's possible bias against fast food companies. The court therefore allowed the peremptory challenge, noting that it was not sure that Batson applies to sexual orientation. After the close of evidence, Sardis moved for judgment as a matter of law, arguing that reassignment under the ADA was mandatory, and Sardis was therefore entitled to judgment as a matter of law. The motion was denied. Sardis and Chick-fil-A each provided the court with special jury instructions regarding the ADA. Chick-fil-A's instruction stated, reassignment of a disabled employee who is not the most qualified applicant to a vacant position in contravention of an employer's most qualified hiring policy is presumptively unreasonable. To overcome this presumption, the disabled employee must show that it was unreasonable for the employer not to make an exception to its most qualified hiring policy. Sardis's alternative instruction read, so long as reassignment does not create an undue hardship on the employer, it is mandatory that employers reassign an employee unable to perform his or her current job due to a disability to a vacant position of similar pay and status for which they are qualified. The court gave the jury the special instruction requested by Chick-fil-A. The jury returned a verdict for Chick-fil-A. After the verdict, Sardis renewed her motion for judgment as a matter of law and moved for a new trial under Rule 59. She argued that the jury instruction on the ADA issue was legally incorrect and that Chick-fil-A's use of a peremptory challenge against Juror 8 was discriminatory and unconstitutional. The district court denied both motions and Sardis appealed. The 12th Circuit reversed the district court on both issues, holding that 1, the ADA required Chick-fil-A to reassign Sardis into the vacant analyst position regardless of its best qualified hiring policy, and 2, sexual orientation is a suspect class entitled to heightened scrutiny, and the peremptory strike in this case failed the test announced in Batson versus Kentucky. Chick-fil-A petitioned the Supreme Court for a writ of certiorari, which was granted. In a few minutes, we will hear arguments on both issues. This afternoon, Andrea Hagiani and Patrick O'Connor will argue on behalf of the petitioner, Chick-fil-A. Joseph Peacock and TJ Gill will argue on behalf of the respondent, Amanda Sardis.
Thank you, Amanda. The board is proud to introduce the 3 distinguished members of our legal community who will be serving on our judicial panel this afternoon. Serving as Chief Justice is the Honorable Andrew Hurwitz. Judge Hurwitz serves on the United States Court of Appeals for the Ninth Circuit. He was appointed by President Barack Obama in 2012. Before being appointed to the appellate court, he served as the Vice Chief Justice of the 5-member Arizona Supreme Court. Judge Hurwitz earned his A.B. in Public and International Affairs, cum laude, from Princeton University in 1968. He received his J.D. from Yale Law School in 1972. After law school, Judge Hurwitz served as a law clerk for Judge John Newman on the Federal District of Connecticut, John Joseph Smith of the United States Court of Appeals for the Second Circuit, and ultimately Justice Potter Stewart of the Supreme Court of the United States. Prior to his career on the bench, Judge Hurwitz practiced law for nearly 30 years in Phoenix, Arizona, as an associate and eventual partner for the law firm of Osborne Maladon. Also judging this afternoon is the Honorable Goodwin Liu, who serves as a justice on the Supreme Court of California. Following his graduation from Yale Law School, Justice Liu clerked for Judge David Tuttle on the U.S. Court of Appeals for the D.C. Circuit, and then worked as a special assistant to the Deputy Secretary of the U.S. Department of Education. He went on to clerk for Justice Ruth Bader Ginsburg of the United States Supreme Court during the October 2000 term. He then joined the appellate litigation practice of O'Melveny and Myers in Washington, D.C., before joining the faculty at the UC Berkeley School of Law. Justice Liu was appointed to the California Supreme Court by Governor Brown in 2011. Also judging this afternoon is the Honorable O. Rosary Thompson. Judge Thompson serves on the United States Court of Appeal for the First Circuit. She was appointed by President Barack Obama on October 6, 2009. Before being appointed to the appellate court, she was formerly a Rhode Island Superior Court Justice and a judge for the Rhode Island District Court. Judge Thompson earned her bachelor's degree from Brown University in 1973 and her JD from the Boston University School of Law in 1976. Prior to her career on the bench, Judge Thompson was a law clerk for the Harvard Legal Aid Bureau, an associate for the law firm of McKinnon and Fortunato, an assistant city solicitor for Providence, Rhode Island, and worked in private practice. The arguments today will last approximately 1 hour. If at this time you could please turn off your phones or at least turn them on silent, and if you could please be seated for the entirety of the argument and remain as quiet as possible while the argument is taking place. We will take a brief break following the conclusion of the argument. Now, we will begin the final round. Bailiff?
All rise. The Honorable Chief Justice and Associate Justices of the Supreme Court of the United States.
Good afternoon. We're here today to hear argument in Chick for Me, Inc. versus Sardis, number 15-465. Counsel, you may proceed. Normally, we don't do that in the Supreme Court, but we'll do it today. Would you please announce your appearances?
Good afternoon, Your Honors. Andrea Haggiani, co-counsel for Petitioner, Chick for Me Incorporated.
Good afternoon, Your Honors. My name is Patrick O'Connor. I also represent Chick for Me, and I'm going to be speaking on the Batson issue.
Good afternoon, Your Honors. Joe Peacock, representing Respondent, Amanda Sardis.
Good afternoon, Your Honors. TJ Gill, representing Respondent, Amanda Sardis.
And now, counsel, if you're ready, you may proceed.
Good afternoon, Your Honors. May it please the Court. Andrea Haggiani, co-counsel for Petitioner, Chick for Me Incorporated. At this time, I would like to reserve 1 minute for rebuttal.
You may.
Thank you. This afternoon, my co-counsel, Patrick O'Connor, will argue that the removal of Juror 8 was constitutional. I will argue that the judgment of the Court of Appeals should be reversed for 3 main reasons. First, because mandating reassignment contradicts the ADA's plain language and legislative intent. Second,
Why?
Well, Your Honor, the ADA states reasonable accommodation may include reassignment. The permissive may, used in contrast with shall elsewhere in the ADA, indicates that while reassignment might sometimes constitute a reasonable accommodation, it does not always constitute a reasonable accommodation. The ADA still requires the employer to demonstrate that the reassignment would in fact be reasonable.
Why wouldn't mandatory reassignment be consistent with the remedial purpose of this legislation?
Well, Your Honor, the ADA does have a remedial purpose, but it also balances the interests of businesses with the interests of disabled individuals. And here, the business interest involved with best qualified hiring policies outweighs the interest in reassignment.
Would you admit, would you not, that the statute isn't a model of clarity?
It is not, Your Honor.
So we have the EEOC, which is the expert agency supposed to interpret the statute, and they tell us that mandatory reassignment is required under these circumstances. Why shouldn't we give Chevron deference to their interpretation?
Well, Your Honor, in the EEOC's regulations, it never actually states that reassignment would be required in a situation as this. It still states in the EEOC that reassignment is only required when it wouldn't be an undue burden and it includes the language of reasonableness. The only place the EEOC actually discusses reassignment in contravention of a best qualified hiring policy is in its enforcement guidance, which should not be given Chevron deference because it didn't have notice and comment.
Is there any dispute that you have as to Ms. Sardis's qualification for the position?
No, Your Honor. Ms. Sardis was minimally qualified for the position.
So what's so unreasonable about the reassignment?
Well, Your Honor, when we consider unreasonableness as the court in U.S. Airways Incorporated versus Barnett discussed, reasonableness considers the burden that would ordinarily be imposed on all employers who implement this policy.
Well, Barnett was a seniority case.
Your Honor, the facts of Barnett did pertain to a seniority policy. However, the test established in Barnett should be applied to any reassignment.
Well, but the facts matter. I mean, seniority is very different, because there you're talking about people's entrenched expectations over a long period of time. Here you're just talking about the employment at the initial phase of people sorting themselves into position. There's no set of expectations, really. And in fact, to the extent there is any expectation, if your position is that only the best qualified should get the job, I don't really see how there's any room for reassignment then, because Ms. Sardis would just then compete like any other applicant for these positions, and presumably, the notion of reassignment would be read out of the statute.
Not necessarily, Your Honor. Just like in Barnett, where the court said in that particular circumstance, reassignment is not required, what we are asking the court to do is determine that in contravention of a best qualified hiring policy, it would ordinarily be unreasonable.
But focus on the difference, if you would, between a seniority policy. Mr. DeCamp had no expectation that he was going to get this job, did he?
Your Honor, I do believe Mr. DeCamp did have expectations that he would get the job.
Because you've got a five-factor policy that leaves ample room for the employer to decide who it wants to promote and who it doesn't want to promote. And so Mr. DeCamp, unlike somebody in the seniority system, didn't say, well, if I serve my time, I'll be the next person to get the job. He still had to impress the employer, if you will, correct?
Yes, Your Honor.
And so in this system, since you admit that Ms. Sardis is qualified, what's the burden on Chick for Me? Why is it unreasonable for Chick for Me to have to promote a qualified disabled person to this job?
How is it a burden at all?
Well, Your Honors, there's a multi-layered burden here. The first burden we have to consider is the fact that Chick for Me has put time and effort and money into implementing this same policy for more than 10 years. And undermining that policy in order to reassign Ms. Sardis would negate many of the benefits associated with the policy.
Well, that's
A seniority policy is objective. You can look to see who's been there the longest and make a readily available determination that this person is the most senior. This most qualified policy, though, is full of subjective analysis, which could be used to exclude at an employer's whim anyone that wishes to do so. And in this situation, this particular employee, the competitor, didn't, once again, have an expectation that he would get the job because he had no entrenched interest.
Well, Your Honor, first, seniority policies are not quite as objective as they might seem on their face. First of all, employees don't know who, generally, such as the seniority system used in U.S. Airways, the policy required bidding. So an employee didn't know whether or not they were going to be the most senior because they couldn't know who was going to bid.
Well, but if they were the most senior, they were entitled to the job, correct?
Yes, Your Honor, but how they defined most senior wasn't actually clear. They may have, we don't know how they considered part-time versus full-time employment, how they considered vacation time or leaves of absence.
But you do agree that Mr. DeCamp was not entitled to be appointed to this job?
He was, Your Honor, because he was the best qualified applicant for the position. And Chick for Me's best qualified hiring policy does create expectations of fair and uniform treatment.
Well, let's assume that, let's just assume for the time being that he was the most qualified. You don't represent him. You represent the company, okay? So the question is, what's the burden on the company, not the burden on him? And I still don't really understand what the burden is, because even if you said that this is in contravention of the policy, which, as my colleagues have inquired, may not even be the case, but let's just assume it is, this is a special circumstance. That's why the ADA exists. It doesn't overturn your policy. It just means that your policy must give way to other obligations in this kind of case. But for the minor run of cases, your policy is fine. Why is that such a burden?
Well, Your Honor, it's a burden, as I said, first because it does undermine the best qualified hiring policy, but additionally, the ADA indicates that we should be looking not just to the financial resources of the company as a whole, but also to the size and financial resources of the specific department she is seeking reassignment to. What we're dealing with here is a department comprised of 4 individuals, 3 analysts and 1 assistant analyst.
Are you
But
worried she can't do the job?
Yes, Your Honor.
But I thought you said there's no dispute that she is qualified to do the job.
That's what stipulating to being qualified means, that you're admitting she can do the job.
Your Honor, she's minimally qualified for the position. However, these qualifications, the job requirements that Chick for Me created were likely created with the knowledge that Mr. DeCamp was going to apply for the position. And additionally, they probably created lower qualifications in order to leave room for an applicant who, although they only had...
Does the record bear that out anywhere?
No.
I've seen the record in this case. There's no indication that Chick for Me designed these policies in some way to allow less qualified people to apply. She's qualified. So what's the burden on Chick for Me in putting her in this position?
But your argument just undercut your whole premise, which is that the other applicant, Mr. DeCamp, was the most qualified. You're saying that now the job was put together just with him in mind? That undercuts best qualified.
Not at all, Your Honor. All of the analysts currently have master's degrees in statistics, and they probably knew that Mr. DeCamp was going to apply for the position. However, setting lower job requirements allows room for someone who has 10 years of relevant experience working as an analyst in a different company to apply. If they set the standard at a master's degree, that would exclude the applications.
Well, whose fault is that? I mean, that's what your company chose to do. So, I mean, you've made your bed, now you have to lie in it. And, I mean, if that's what you set the qualifications at, and you say it's undisputed that Ms. Sardis is qualified, it seems to me that your argument on burden is, it's still hard to discern what exactly is the burden. Unless you're trying to now tell us that she actually isn't qualified, because what you did was you lowered the set of qualifications, as you say, to make room. But that's your own doing.
Well, Your Honor, Chick for Me relies on its best qualified hiring policy in order to ensure that it's going to receive the best applicant. But also, if we just look to the size and financial resources of this department, there's no formal training process. Ms. Sardis has absolutely no relevant work experience. Her bachelor's degree is not relevant to an analyst position.
Well, and if you had concluded, if your client had concluded that she couldn't do the job, I'd understand it. If your client had concluded that the qualifications for the job were higher than the ones that she had, that would make some sense too. But you've stipulated that she's qualified to do the job. And so I'm not sure what difference it makes what your client's intent was in setting up the system. What's the burden? The statute requires that there be an undue burden on you. What's the undue burden on your client?
Your Honor, the undue burden is that Chick for Me would be forced to hire an applicant who has no relevant work experience in a position, in a department where there's only 2 other analysts. That means that the other analysts are going to be forced to leave their job duties to provide training for Ms. Sardis, and that means that not only are they going to be burdened with more work, since Ms. Sardis in the beginning will not be able to complete the duties of an analyst, but additionally, that also means that they're going to have to take time away from the work that they would be doing to train her. Furthermore, in the analyst department, there is an informal training process that is implemented, and all of the analysts contribute to that informal process by sharing their experience and by training each other. Ms. Sardis wouldn't even be able to contribute to that informal training process because she has no relevant work experience. So what we're dealing with here is a very...
Well, it sounds like that you put together an inappropriate job description for the position. If you wanted someone who was more qualified, then that would have been the resolution to that problem. But having put together what you deem to be the essential qualifications for the job and having stipulated that she meets it, not only do I not see how it's an undue burden, I don't see how it's a burden at all.
Well, Your Honor, even if Chick for Me did set the qualifications too low, all the ADA says is that we need to consider the financial burden, the the difficulty and expense on the employer.
But you didn't put in any evidence at trial, as I see it, that she wasn't qualified to do this position. Just, in other words, I'd be fine if your qualifications were broad, and then you said, we've taken a look at her and she just can't do this job. But you don't say that. You stipulate that she's qualified to do it. And so I'm not sure why it makes any difference where you set the qualifications once you stipulate that she's qualified to do this job. She not only has the qualifications to apply, you've stipulated that she's qualified to do the job, haven't you?
Yes, Your Honor. However, we've stipulated that she's minimally qualified. However, the undue burden test provided in the ADA doesn't say that it's never an undue burden if an individual is qualified for a position. All it says is that we consider the financial burden, the financial resources and size of this.
Could I back you up and ask you then a legal question?
Yes, Your Honor.
So the EEOC guidelines, I'm going to return to the Chief Justice's question about the EEOC guidelines. Do you at least acknowledge that under the EEOC guidelines, you would be required to reassign her in this way? You're arguing for the invalidity of the guidelines, are you not?
Just to clarify, you're talking about the interpretive guidances.
Right,
Yes.
not the reg,
Yes.
but the guidelines.
Yes.
Yes, Your Honor. At least insofar as they deviate from this court's decision in Barnett and from the plain language in the ADA, then yes, this court should
Okay,
not follow.
I guess I'm sort of wondering what the deviation here is. Seems to me that the statute is pretty broad. It just says accommodations may include the following, which includes reassignment to a vacant position, and leaves it at that. Doesn't say under what conditions, doesn't say in what circumstances. And the agency entrusted with interpreting the statute, the expert agency here, has said, okay, it's required under these circumstances. What's inconsistent about that?
Well, Your Honor, the ADA does narrow the scope of the accommodation requirement by using the word reasonable, which this court identified in U.S. Airways Incorporated versus Barnett. It would not be reasonable here to reassign and undermine a best qualified hiring policy.
Well, I mean, but that's sort of a circular argument because the agency has simply said it is reasonable. And, you know, in their expert judgment, this is reasonable. So are you taking issue with the you're taking issue with the agency's judgment that under no circumstances could this possibly be reasonable?
No, Your Honor. In the EEOC guideline, the interpretive guidance, they don't even address the issue of reasonableness. The only limitation they place on the reassignment accommodation is that it not pose an undue burden on the employer. Your Honors, I see my time has run. May I briefly conclude?
Isn't that undue burden notion, that is the acknowledgement of reasonableness, is it not?
No, Your Honor. Reasonableness also considers the general burden which would be placed on all employers, and it would generally be too burdensome on employers to reassign in contravention of longstanding best qualified hiring policies. And for that reason, Your Honors, Chick may respectfully request that this court reverse the judgment of the Court of Appeals. Thank you.
Thank you, counsel.
Before I begin, may I reserve up 1 minute for rebuttal?
You may, and we'll put a little time on the clock to allow your co-counsel to have rebuttal time since we cut into her time.
May it please the court. This case does not fall under Batson, and this case should not fall under Batson.
Is that because sexual orientation is involved? Is that the only reason why it doesn't fall under Batson?
No, Your Honor. There's two reasons. One is that sexual orientation classifications are not covered by Batson. The second one is that sexual orientation was not the motivation for this strike.
Okay, let's focus on the first for a while. I understand you have these two parts, but I just want to focus on the first for a second. You acknowledge that if the situation involved another suspect category, race or gender, let's say, you know, your client's CEO had made disparaging remarks against women, and this was well known, and that if at trial counsel had struck one of the jurors because she was a woman, that this would clearly be in violation of JEB, Batson, that line of cases. It would. And similarly, if your CEO had made anti-Asian remarks and you struck an Asian juror just because they were Asian, then that would be in violation.
Yes.
Yes. So here you have someone who has made anti-gay remarks, right? And if trial counsel had simply said, I'm striking juror, is it 5 or 8? Which one is it?
It's juror 8.
8. If I'd struck juror 8 because I suspect the person is gay, you're telling me that that would not be a violation of the equal protection principle?
Correct.
You don't really believe that, do you?
I do, Your Honor.
Why?
Because starting with JEB, this court made clear that classifications that are only subject to rational basis do not get Batson protection.
What
So
about
what's the
classifications that are subject to a somewhat more heightened scrutiny, but not strict scrutiny?
Well, Your Honor.
For example, gender.
Yeah, Your Honor.
Gender gets Batson protection, does it not?
Yes. Suspect class and Batson protection do not, at least under the jurisprudence of this court, move in lockstep so
Right,
far.
so the question is whether or not the classification is one that gets some heightened level of scrutiny by the court.
Yes.
What's our jurisprudence on that with respect to sexual orientation? I would think one would take out of Lawrence and Obergefell and Windsor that there is some heightened level of scrutiny here.
Well,
Court
Your
certainly didn't deal with those cases on a rational basis test, did it?
The window of cases we look at goes back to essentially Romer versus Evans in 1996. And that was when the court used what some people have called a heightened version of rational basis. But since Romer versus Evans, even after Lawrence and Windsor, the majority of circuits have still continued to proceed with the
Well, but
exception.
you're not in the circuits now. You're up in the Supreme Court of the United States. So haven't we applied a higher, Romer certainly applied a higher level of scrutiny than simply rational basis, didn't it?
Well, in Obergefell and in Windsor, the most recent cases, this court had an opportunity to confer suspect class status on these classifications. No mention of suspect
Okay,
classification
so
was
let's
made.
assume you're right.
Wasn't it
Why
de facto?
shouldn't we?
Say again?
In Obergefell, wasn't it in fact a de facto heightened scrutiny, even though they may not have called it that?
Well, in Obergefell, the Justice Kennedy spoke of the intertwining relationship between fundamental rights and equal protection analysis and how sometimes they inform each other. I think what's distinct about those cases, specifically the gay marriage cases in Lawrence versus Texas, is that is areas of the law where before a person can participate or engage with it, their sexual orientation is necessarily implicated. You have to be getting married or you have to be having sex. That's different from most cases where your sexual orientation is not wrapped up in your interaction with the law. And this goes to one of the 4 factors this court mentioned in Cleburne and in Frontero, the factors they use to determine suspect class.
Well, that gets back to Judge Liu's question, which is if your client has been making these anti-gay comments and demonstrating, and the juror, in fact, has made known that they're gay, his question to you was, would that trigger Batson protection? And you said no, and I'm trying to figure out why. Given that hypothetical, it wouldn't.
In JEB and in Batson, the court essentially added a 5th factor in order for a suspect class to get Batson protection. And that was a history of specifically discrimination within the jury veneer. It's important to remember that Batson was the result of a century-long effort to eradicate the exclusion of blacks from juries. And that existed because there was...
This is very different, though. I mean, I understand all that you're saying, but and I understand all that you're saying about the doctrine and equal protection and these different tiers of scrutiny. I'd like to take you back, though, to just some basic common sense and reasoning. Forget about the doctrine for a second. Why isn't it discriminatory to simply strike someone on the basis of their status because you think that status will interfere with their ability to be fair in this trial? Can you just sort of speak to that in plain English? Forget about the legal mumbo-jumbo here. I just want to hear what the reasoning is for your position.
Your Honor, if that strike did happen, I assume that the common sense logic would be this juror is gay, the CEO is known for these donations, and therefore they're going to feel a personal affront from this corporation.
But isn't that why we have step 3 of the Batson analysis? What Judge Liu is asking is a different question. Why should we sanction a court system in which challenges to people on the basis of their sexual orientation are permitted?
For the same reason that we sanction a court system where challenges based on disability or mental retardation are permitted. It's not necessarily something that feels good, but this is what happens.
Why isn't the same thing applicable to race then? I mean, if the imperative on the other side is some notion that you want a fair jury and you don't think that these people can be fair, how does that distinguish the race and sex examples that I gave you?
Your Honor, again, the Batson was created to prevent that history of exclusion from the veneer. But on its own...
But that history was a history of just blanket exclusions. Here you have a very specific rationale. The rationale is you have a client whose CEO has made let's say anti-black comments. And it would stand to reason that a black juror, a black prospective juror, might be quite offended by that, just as a gay juror might be very offended by the anti-gay comments. I don't see any distinction among these scenarios.
That's fair, Your Honor. But it goes back to what this court said in the 19th century, which is that the peremptory strike is an arbitrary and a capricious right.
Well, maybe we should do away with it entirely, but that's not where you come into court today. You come into court suggesting that it's perfectly okay at step one of the Batson analysis for somebody to say, I don't want you on the jury because you're gay.
Is that your real position?
Is that your position?
Your Honor,
I understand you have a step three analysis,
Sure.
but let me focus on step one. Is it constitutional for somebody to say, I don't know whether you'll be biased or not. I'm not worried about the facts of this case. I just don't want a gay person on the jury. Constitutional or not?
Your Honor, I think under the current body of law, yes, it is constitutional.
No, you told Judge Liu that you obviously had another argument, and that's on step three. Let me ask you a question. Did the judge make a step three finding in this case?
She did, Your Honor.
I'm looking at the record, and the judge says, she says something like, you've proffered a non-discriminatory reason. That's step two, and we all agree that you get past step two because you had a non-discriminatory reason. I don't want a gay person because they might well be biased against my company because my company says the following things. But where's the finding that this wasn't a pretext?
Your Honor, the judge goes through the steps. She says first, she goes through the steps in perfect order.
Right, we have 1 and 2. Tell me where she finds 3.
Where's the step three, the totality?
Well, she
Looking
makes clear because the trial court was actually asked to make a separate expansion on her finding, right? And in there you'll see on I apologize for the page number, but
it's in her post-trial rulings.
it is on page 38, Your Honor. She explains that the third step, where she finds clearly that the explanation, the neutral explanation, was more reasonable than the.
It may be more reasonable, but doesn't she have to find whether it's pretextual? Isn't that what the court said? We rely on the district judge to look at a reasonable explanation and see whether or not it's really a pretext for discrimination.
There's no verbatim requirement for how the judge has to phrase it. I think that the judge saying this one is more reasonable than the discriminatory purpose is enough to show that she is following step 3. And if she did follow step 3, which I believe she did, Your Honor, and the fact and the record supports it, then the most important fact in today's case is that the appellate court used the wrong standard of review. The proper standard of review for whether or not the trial court made the right finding on intentional discrimination is clear error, and it's clear error for a reason. As Justice O'Connor said in Hernandez, this is a decision that is peculiarly within the trial court's province. There's things we don't have on a stale record. The sound of a lawyer's voice, the look on the juror's face. The trial court had all of that, along with what we have in the record. And Judge Holbert found that the neutral explanation was the more reasonable explanation. And the record supports that.
I think that the law is somewhat on your side on that point. I take that. I want to return to the question of discrimination then. I mean, I'm still sort of stuck on what you think the legitimate governmental interest here is that would justify this kind of, it is a form of discrimination. Whether or not it's an actionable form, that's debatable, which is what we're debating. What is, even under rational basis review, okay, let's not get into quibble about the tiers of scrutiny. Even on rational basis review, what is the rational basis that the government has for tolerating this kind of discrimination?
It's the basis that Justice O'Connor spoke about in her dissent from JEB, or her concurrence, where she said, I do agree with extending this to women, but we got to be careful. Because, as Your Honor said, as long as we're going to have the peremptory strike as a right, which this court has found is a guaranteed right to civil litigants, then it doesn't work unless it's an arbitrary and capricious right. We don't necessarily have to agree that the decision to strike a juror based on their sexual orientation is a good one or one that's going to affect the trial, to say that it is something the counsel is allowed to do with their peremptory strike.
That's this line drawing. And so the question is, why do you draw the line there? Why do you say, okay, women, you can't do it, minorities, you can't do it, but it's okay to do it for gays who have been historically discriminated against, of course?
Well, I think there's another factor the court takes into account when they decide whether to extend Batson, and it's that extending Batson is a major step. I mean, you're adding a new potential structural error in a trial if a trial judge gets this wrong. And so when we add more law, we invite more litigation. And right now, juror sexual orientation is just not a major part of the voir dire in most cases.
Well, that's not really true, because having been a trial judge for so many years, a person is always asked to talk a little bit about themselves and their significant other. And if the significant other is a person of the same sex, they talk about it.
It comes up.
It always comes up.
Sure, but what we don't have right now is the attempt to perform comparative juror analysis to determine whether a Batson challenge, like the one in this case, is correct or not. And in order to do meaningful comparative juror analysis, the counsel bringing the Batson challenge is going to want to know the sexual orientation of every single one of those jurors. So it's possible that the exact privacy and the dignity that this court sought to protect in Obergefell and in Lawrence, that extending Batson to cover sexual orientation would do the exact opposite.
That's not really how comparative juror analysis works, though. I mean, comparative juror analysis is just done on the basis of the record that's given. I mean, you don't necessarily need to further inquire if people haven't revealed certain information about them. I mean, because what you're trying to do is you're trying to suss out what the prosecutor has, in the criminal case, or in this case, the defense, has done on the basis of the information then available. And in this case, you have two jurors, and there's a claim here, right, that they've treated one more favorably than the other. But there is no need to inquire further of jurors 1, 2, 3, and 4, or numbers 9, 10, 11, 12.
Well, Your Honor, this court has only overturned a trial court's finding of no intentional discrimination 3 times. And if you look at a case like Miller L., where it was done, a major part of that decision was a comparative juror analysis saying 9 out of the 10 peremptory strikes used were on black jurors, and yet only less than 20 of the jurors in the original pool.
What do we know about Juror 5?
What we know about Juror 5 is that Juror 5, we don't know whether or not Juror 5 is gay or not. We do know Juror 5 avoids eating fast food but has eaten at a Chick-fil-A.
So the only difference in terms of the reason for challenging Juror 8 and leaving Juror 5, the only 2 conceivable differences are that one, Juror 5, when forced to, will eat chick for me, but really doesn't want to. And is there any other difference between those 2 jurors other than the sexual orientation?
I don't think so, Your Honor, but I think the first
So why
one...
can't we do comparative juror analysis? Does it really make a difference that Juror 8 won't do it ever and Juror 5 will only do it if a gun's to his head?
Well, saying I avoid it but I eat it when it's the only thing available, and saying no, never. I see my time's run out. May I finish answering the question? And saying what Juror 8 did, which is never, and then unprompted saying, wouldn't it make me a hypocrite to eat at that restaurant? That's a horse of a different color, Your Honor. And it's the matter of degree in the fact that our counsel chose to strike the juror who gave the more extreme answer about fast food that supports the neutral explanation. So given that and all the foregoing reasons, we respectfully ask that you overturn the appellate court's finding and reinstate the trial court's decision. Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Joe Peacock, co-counsel for Respondent Amanda Sardis, and I'm joined by co-counsel Mr. Gill, who will be arguing that the District Court improperly denied Ms. Sardis's Batson objection. And Your Honors, I will argue that this Court should affirm the 12th Circuit's decision that reassignment in contravention of an employer's best qualified applicant policy becomes mandatory as an accommodation of last resort under the Americans with Disabilities Act for the following 3 reasons. First, the ADA expressly enumerates reassignment to a vacant position as a reasonable accommodation. Second, the Equal Employment Opportunity Commission, the agency entrusted to administer the Act, provides a clear guideline as to when reassignment should become mandatory. And third, the present case is distinguishable from this Court's decision in United Airlines versus,
Okay, so can I ask about this notion? We peppered your friend on the other side with lots of questions about qualification, okay? So the record indicates that the parties stipulate that Ms. Sardis, your client, was qualified.
Yes, Your Honor.
Right. Now, there's qualified and then there's qualified, right? I mean, you have to concede that there's a range of qualification. You went to a very fine law school, I see. right? That law school did not simply admit every minimally qualified individual to attend the law school. I imagine if it did, you would have gotten a less good education at that law school, right? So if we asked your alma mater to admit every minimally qualified student, I would say that's a significant burden on that school. And why isn't the same applicable here?
Well, Your Honor, on page 43 of the record, Chick for Me has stated that Ms. Sardis is qualified.
Well, she's qualified, but there's qualified and disqualified, as Judge Lewis just asking. What if Chick for Me thought she's qualified, but Mr. DeCamp is a superstar? He's the kind of person that might get into a selective law school. Why? Isn't it an undue burden on them to take the qualified but not quite as good applicant?
It is not, Your Honor. Being minimally qualified versus what the EEOC mandates, if this court does decide to defer to it, which I would ask the court to defer under Skidmore deference. And the act is supposed to put disabled applicants into the economic and social mainstream.
Well, but to be fair, Chick for Me didn't take your client out of the mainstream. She had a job, a part-time job. They offered her a full-time job. It paid a little bit less per hour, but had benefits. But they thought they had a better applicant for this job. Why isn't it an undue burden on a company to put into a small department somebody who they don't think is as good as somebody else? They did their five-step analysis and thought Mr. DeCamp came out better under it. That was their judgment. Why isn't it a burden on them to require them to take a person that they don't think is quite as good?
And specifically, why should they have to abandon their best qualified policy that they have consistently applied for over a 10-year period?
Your Honors, the facts of the case, the analyst position trains on the job as soon as they arrive on scene. Ms. Sardis has an undergraduate degree, which the position does require, only merely recommends a graduate degree. Here, Ms. Sardis also, by taking an administrative assistant position, would be demoted because she's taking a $6 less per hour.
But she might be demoted, but the statute requires only reasonable accommodations. Do we agree?
Yes, Your Honor.
So why is it unreasonable for an employer to say, there's two jobs open. You're qualified for both of them, but we have a better applicant for the other one. So we'll give you the second one. Why is that unreasonable? Again, stepping back and not relying on case law, but stepping back. What's unreasonable about it?
It's going to have no serious effect on Chick for Me, Your Honor. She is qualified. Additionally, under the EEOC guidelines, when there are two open positions, the EEOC has, within its expertise, has already set out a list of question and answers for which an employer consults in these difficult ADA compliance decisions. And one of those rules that the EEOC provides for an employer in this difficult decision has to make is that if there are two open positions, the employer must provide that reassignment to the position that comes closest to the original position in terms of pay and status.
Unless it presents an unreasonable burden on the employer.
Yes, Your Honor. But again, on page 43 of the record, Chick for Me does state that she is qualified for this position.
Well, but that's not the question. Is it an unreasonable burden not to have the best qualified person in the position as opposed to someone who's just qualified?
It is not, Your Honor, especially given the facts of the present case that there are two other data analysts who do have masters in statistics. And under this case, they can take her in, Ms. Sardis, under their tutelage, and they do train on the job. And so here,
but why isn't it reasonable? Why is it unlawful, in fact, under the ADA for them to apply their long-term policy of hiring the best qualified? Isn't it a policy that's put in place because the workforce has an expectation that if they work and do their best, or if an applicant is the best, then that's how the company is going to make its decisions? Isn't that a legitimate employer policy?
It's certainly a legitimate employer policy, Your Honor. However, the Seventh Circuit in EEOC versus United Airlines has kind of thought this out, this exact issue we have with a best qualified applicant policy and whether or not that should overcome any policy, especially the best applicant, over a long period of time. Here, the reassignment is only given on a very limited basis, on a last resort basis. It's after a failed, either crescendo of failed accommodations that were attempted by the employer.
No
or if not-
crescendo of failed accommodations here.
No, Your Honor. The record does state at page 43 that essentially there were no accommodations that Chick-fil-A could provide her at the outset.
Well, it did provide her with an accommodation, it's just not one that you're happy with.
No, Your Honor, and especially under this rule with the 2 vacant positions under the EEOC, by taking a look at the administrative assistant position and then the analyst position from her original checker position, a reasonable employer is going to see down the road in Ms. Sardis's career downward mobility. Here, the administrative assistant position is not an autonomous position.
Let me change the facts on you just a little bit. Let's assume it's not Mr. DeCamp. Let's assume it's the best analyst in the country who applies from the outside for this job. He is superb. He's been analyzing this stuff forever, and everybody agrees he's the best analyst in the country. And your client is qualified. Under your view of the law, are they required to promote your client to this position?
Absolutely, Your Honor. Preferences are sometimes necessary to put forth the action.
Is this essentially affirmative action policy?
It's a preference policy, Your Honor.
Affirmative action policy.
It may be viewed as an affirmative policy. I will give you that, Your Honor, yes. But that comes from the language of this court. Under limited circumstances, preferences are sometimes necessary.
You keep saying it's limited. Okay, so I guess I'm just sort of wondering how we evaluate the burden question here, right? Let's say you're right that this is limited in the sense that this is one position at this company. But you know what? Every litigation is about one position at one company. And we're here being asked to make a rule that's essentially going to affect every company for every position. So the burden analysis can't just be about what's happening at Chick-fil-A. Don't we have to take that question in the aggregate, which is to say, what will be the aggregate effect on businesses nationwide?
Absolutely, Your Honor, we should. And in fact, taking businesses in the aggregate nationwide, in this country, as a capitalist economy that it is, every company wants to provide or retain the best qualified applicant.
Right. So the burden is very significant because every time we have this affirmative action policy, we're going to get a less qualified person.
However, if this court were to rule that reassignment does not trump a best qualified applicant policy, it would strike the reassignment provision altogether from the ADA, as it already has under a seniority system in the vast majority of...
But you're not contending that Mr. DeCamp wasn't the best qualified applicant. I'd understand if you made a factual showing that despite all these qualifications, your client's really better at it than he is. Don't we have to take it as a given that he was the best qualified applicant, given their criteria?
Yes, Your Honor. It does state that Mr. DeCamp was better qualified. We're tasked with the difficult issue of having to balance the rights of Mr. DeCamp.
Well, what's the broad general rule, though, based upon Judge Liu's question to you? What's the rule you want us to apply in every case? That as long as a disabled person has minimal qualifications, that they have a right to be reassigned to an open position? Is that the rule you want us to adopt?
Yes, Your Honor, on a last resort basis.
Well, but you keep saying that, but I'm not sure what the last resort means. Does the
What does that
last
mean?
resort mean that there's no other job in the company for them, or that they don't like the other job they were given?
From the last resort basis, Your Honor, the reassignment should be given to an equivalent position, which works in hand with the EEOC's groundwork that it's already laid.
Well, but it seems to me you're arguing for a first resort then, aren't you? Doesn't she get it automatically no matter whether or not, as long as she doesn't get something equivalent to this position, you win under your view. So what's the last resort argument? I don't understand it.
So going back to just the language of the ADA and the statutes.
No, I understand what the language says, but aren't you taking last resort out of it?
I'm sorry, I don't understand your question.
Your argument that she's automatically entitled to reassignment to this job removes last resort from the analysis, doesn't it?
No, Your Honor, it does not.
Tell me how last resort matters here.
Last resort matters because it is going to protect disabled applicants from essentially a constructive discharge from the company. The ADA wants to give flexibility. An employer should certainly have flexibility in determining whether they should be providing reasonable accommodations for their employees. From the employer's side, they have the ability to create any different reasonable accommodation that is reasonable under the circumstances.
An automatic reassignment, you tell us, is the last resort, correct?
Only as a last resort.
Okay, so what, in this case, given your legal position and your answer to Judge Thompson, isn't it the first resort?
No, Your Honor, and I think I may be confused as to from what point you're speaking.
Well, in other words, we don't really have to examine anything else. We don't have to examine whether or not it would be reasonable to give her a job that had benefits but paid a little bit less. What you're saying is it's as long as there's an open position that she's qualified for, she must be given it. That's not a last resort analysis.
Right, and Your Honor, working hand in hand with this as well is the fact that the employer always has the ability to claim undue hardship at the same time. So all of these rules work together. Chick, for me, may certainly claim undue hardship, at which case, if they prove that burden, then certainly, even after a last resort analysis, the employee should not receive that position.
Do you mean by last resort that, I mean, the only way that that has any analytical content, it seems to me, is you're saying that there's some first, second, and third resorts that are available here, and that an employee, like in your client's position, is just going to be deemed to have to accept the first, second, one of those first, second, or third resorts. Meaning at some point it is reasonable what the employer has done, and if the employee doesn't accept that, then it's their problem. That must be what you mean.
Yes, Your Honor.
Because the last resort concept, as the Chief Justice points out, has no content unless what you really mean is that there are some other resorts, first, second, or third, that the employee is obligated to take, or else it's their own problem. The employer is, in other words, not required to do anything more.
So long as there's a reasonable accommodation that is reasonable for the disabled employee, then the employee should take the position if they dispute whether the reasonableness of that reasonable accommodation.
So measure unreasonableness for me. Your argument about unreasonableness seems to be if you're not given a position that's equivalent to the vacant position, that it's unreasonable. Is that correct?
Yes, Your Honor.
Where do you get that from the EEOC statute?
As far as between the difference between two vacant positions?
Yeah. In other words, it would seem to me that a lot of times an employer may have a reasonable position for someone that pays a few dollars less an hour but has benefits. And that's a reasonable accommodation from everybody's standpoint. Why is it unreasonable to offer her this other position? Maybe it's a demotion, but it's got benefits, and she remains in the company and eligible to apply for something later. Why is that unreasonable?
It's unreasonable, Your Honor, because Chick for me here is cloaking a demotion by saying that they are providing her more hours and benefits, especially given the fact—
Well, there's no indication in this record they did so in bad faith.
No, Your Honor, absolutely not. However, this case has broad implications for our American workforce. And if the employer has the ability to read the opinion of this case and see that an employer can cloak a demotion by simply providing an employee with a disability with pain in her legs to work more hours simply because she has benefits, which the record does not state clearly what those benefits are, and the other vacant position also provides full-time and benefits, it seems to, under the EEOC with these two positions, the data analyst position is closest in terms of pay and status.
You started out talking about the EEOC regs and interpretation, and I take it that that's the only place where the law ever talks about being entitled to a certain position. Am I correct?
Well, the 7th, 10th, and D.C. circuits do rule for reassignment.
Well, some of them, the 7th and 10th before, or the 10th and the D.C. before Barnett, correct?
Yes, Your Honor.
So, but if we're talking in memory of Justice Scalia, if we talked about the statutory language, is there anything here that in the statutory language that says one must be given a vacant position?
No, Your Honor, and that's why we're here today. There is certainly ambiguity within the statute. We have a may include phrase, and then we have what some refer to as a menu of accommodations.
Good. Now we're on the same wavelength. And you said before you think we give Skidmore deference to the interpretive reg?
Yes, Your Honor, and I do see my time is up.
But what does Skidmore deference mean? Means we take it if we like it, but not if we don't?
Skidmore deference, essentially, Your Honor, it's a lesser standard of deference from Chevron, and the standard would be to be entitled to respect, being the agency's interpretation. And that's dependent on its power to persuade through its thoroughness and expertise. Seeing that we have a long list, question and answers, where employers go to determine in these difficult employee situations of what they should do, the EEOC has already laid the groundwork here. And Your Honors, for the foregoing reasons, Respondent Amanda Sardis respectfully requests that this court affirm the 12th Circuit's decision and secure the reassignment provision's rightful position in the Americans with Disabilities Act. Thank you very much.
Good afternoon, Your Honors. TJ Gill, co-counsel for Respondent Amanda Sardis. Your Honors, we ask that you affirm the decision of the appellate court for the following reasons. First, because gays and lesbians should be recognized as a suspect class, and thus classifications based on sexual orientation should be examined using intermediate scrutiny. Second, because Batson's protection should be extended to strikes based on sexual orientation in order to protect gay and lesbian jurors from being discriminated against.
Is your first argument necessary?
Is the first argument necessary? Well, this court has never officially declared gays and lesbians suspect class, although I do see your point.
Doesn't that tell you something? We've had many opportunities to do so. Romer, Lawrence, Obergefell. We've not done it. Windsor, we've not done it.
Yes, Your Honor, but...
Why now? We've passed up 4 opportunities to do it. Why now?
Well, because of the right that's at stake in this case, Your Honor. This court in JEB...
It's more important right than the right not to be discriminated against with respect to the fundamental right to marry? The fundamental right not to be criminalized on the basis of your sexual preference?
Well, the difference there, Your Honor, is those were fundamental rights, and when fundamental right analysis is undertaken, strict scrutiny is automatically applied. The court has not declared the right not to be discriminated against on the basis of stereotypes rooted in historical prejudice.
But tell me how it's going to work in this circumstance. And I again invoke Justice Breyer. We can pretty well tell when a strike is made on the basis of race by looking at the juror. Not all the time, but most of the time. We can tell when a strike's made on the basis of gender, I think all the time, by looking at the juror. How are we going to know when a strike is made on the basis of sexual orientation?
Well, as Justice Thompson mentioned, spouses are asked about quite commonly during...
They may be, but a lot of the time, if you sit through trials, you find that they don't really say him or her. Are we going to require jurors to identify their sexual orientation?
No, Your Honor. However, if it comes out, they should still be protected.
So what if you believe that your opponent has struck somebody because of her sexual orientation, because you think she looks like someone? You have gaydar. What do we do? What does the court do? How does the court adjudicate that issue? Does it ask her? What if it's a man who acts effeminate? Does the judge ask him what his sexual orientation is? Aren't we getting into just an impossible measurement issue here? Whereas, at least with gender and with race, most of the time we can look at someone and tell what it is.
Yes, Your Honor. It would be more difficult to understand or to discern whether someone is gay or lesbian. However, it can occur and has occurred in certain situations, such as this case. Moreover, on the flip side, if we do not extend Batson's protections, individuals could blatantly ask about someone's sexual orientation if they do not want a gay juror on the...
No, see, I think a judge can appropriately say, that's off bounds. I'm not letting you ask that question. It's irrelevant to jury service. But now you're putting in a situation where a judge almost has to allow inquiry about it once the Batson objection is made. Isn't that a bad thing?
Well, Your Honor, no real inquiry must be made. Again, as Batson inquiries usually occur, they look at the record to see if there is the basis for a Batson challenge. No more greater inquiry needs to be made than what was made in this case. Juror 8 was not asked whether she was actually a lesbian. The court examined the record to see if there was an implication that her answer is gay or that...
Okay, so you would be okay with the rule that acknowledges that these kinds of Batson challenges can go forward if it is already apparent in the record that the person's sexual orientation has been clearly revealed. How about a clearly revealed standard? Is that okay?
I don't believe a clearly revealed standard would be necessary, Your Honor.
He's trying to help you. He's trying to help you.
It's trying to avoid all the problems that the Chief Justice has just mentioned. You don't want courts to get into this whole inquiry, right? Do you, of inquiring into people's sexual orientation? You just want a rule that says when it has come up, then, there's a prohibition.
Well, yes, I guess...
So why don't we, just to try to narrow this, why don't we adopt some sort of clearly revealed standard so that we cabin the rule you're urging in a way that doesn't intrude too far? Is that okay?
Yeah, we would not be opposed to a clearly revealed standard in that instance, Your Honor. Again, I just doubt that this issue would actually become that prominent, and there's a greater issue of sanctioning these kinds of strikes and the kind of message this sends to the litigants and the rest of the community, an issue that this court brought up in JEB v. Alabama. when it stated at the end of the opinion on pages 145 and 146 that the equal opportunity to participate in the fair administration of justice is fundamental to our democratic system. This
How
is not
far do we take it? I mean, we have a lot of gender fluidity these days. How far do we stretch it? Does it apply to, would you apply Batson to transsexual? I met someone the other day who said I'm neither male nor female, very interesting person. I mean, would it apply to that person?
I'm not sure if it would apply to that person. I believe there must be a case undergone, and this court must undergo the analysis. However,
Well, but you're suggesting, as Judge Liu asked, that for the first time, we undergo the analysis with respect to somebody who's gay and say it's a suspect class. So Judge Thompson is asking, would you reach the same result with respect to a transgendered individual?
as far as undergoing, I'm having a bit of.
Well, no, so let's assume somebody, you find out somebody's transgender.
To what does Batson apply? You're asking us to extend Batson protections to gay people. I'm saying, do we extend Batson protections to transgender people, to gender-neutral people? I'm just trying to figure out, we're talking about either broad or narrow rules. And we're, once again, trying to figure out where do we draw the line. Judge Lewis proposed a narrow concept. I'm trying to figure out how broad you want us to go.
Well, based on my understanding, because JEB did extend Batson's protection to gender, both men and women, on the basis of any sort of gender, you would not be allowed to strike an individual.
Okay, what about somebody who is bisexual?
Again, it's the same as all sorts of extensions of suspect class analysis on the basis of any sort of sexuality.
Well, but I guess I'm asking, would you extend Batson protection to someone who is bisexual?
Yes, Your Honor. Batson's protections would inherently be extended to someone who is bisexual because sexual orientation would be the protected category. The class that we are specifically discussing are gay and lesbians. However, once a class becomes a suspect class, the whole category that defines a class becomes a suspect classification. And if an individual is struck on the basis of that classification, then there's discrimination, and that should not be allowed.
Could you address step 3 of the Batson analysis? If in fact the judge did a step 3 analysis, the trial judge, don't we have to defer to that?
Yes, Your Honor. However, we believe there is clear error in the analysis, and moreover, we do not believe that the trial court judge underwent a...
Well, address the first one. What's the clear error?
Well, Your Honor, as this court stated in Miller L. v. Dredke and Snyder v. Louisiana, comparative juror analysis on its own is enough to overturn a trial court's finding in a Batson inquiry. In Snyder, this court, on page 485 of the opinion, stated that implausible justifications for a strike may and often will be pretext for purposeful discrimination.
But why is it implausible that somebody wouldn't want to? He only had one challenge left. On the one hand, you have somebody who can stomach your food, and on the other hand, you have somebody who can't stomach your food. I picked the person who couldn't stomach it. What's implausible about that?
Well, Your Honor, we do not know how many strikes were left when juror 5 was
Well,
questioned.
the record says the last strike was used on juror number 8. So, but when they got to that point, there was only one strike left. You're arguing a fair person would have struck 5 instead of 8.
Well,
and I'm saying, why is it unfair to pick the worst one?
It's not unfair, it's just logically inconsistent, Your Honor, and that's what makes it implausible. If you're looking for an inference of bias against fast food, Juror 5's answers to the questions posed by the judge and posed by Chick-fil-A's counselor in the voir dire process created an inference of bias. And
Don't you agree that she had a greater bias against fast food than juror number 5?
To a slight degree, yes, based on her answer on page 7 of the record.
But isn't that a difference? Is that a plausible difference?
There is a plausible difference. However, once Juror 5 came to the stand, Chick-fil-A's counselor in the voir dire process had no idea that someone with an even greater bias would come up than a personal trainer who does not like eating fast food, who would only eat it if it's the only thing around.
Isn't that why we have trial judges? This trial judge was at the scene. She saw the counsel for Chick-fil-A, and she said, you know, I don't think he did it for that reason. I think he did it because of the fast food reason. Why is that clear error?
Because, Your Honor, with the comparative juror analysis, perhaps that on its own may not reach the standard, but once Chick-fil-A's counselor during the voir dire process was questioned about the reason for a strike, or once the Batson challenge was issued, on page 7 on the record, on page 8 of the record, he states that it was impossible to know what Juror 8's sexual orientation was. Once Amanda Sardis's counselor during the voir dire process stated that her answers clearly implied that she was gay, when on page 6 of the record, she twice used the feminine pronoun to refer to her spouse, and stated that she worked at an LGBT community.
Your suggestion then is that that's a giveaway, that implies the, in a sense, the uncredibility of the defense counsel.
It detracts from the credibility, and once Amanda Sardis' counsel during the voir dire process brought this up, he stated, well, okay, maybe she has a female spouse. This is on page 9 of the record.
Okay, all right, I take all that. Let me back you up then and ask, just again from the standpoint of common sense, okay? We want a fair jury, and we want a jury that's free of unwarranted biases, right? Don't you think that in light of the inflammatory things that your opponent's CEO has said in the past, that if a person truly is gay, that they might look askance at the defendant, and that would impair the fairness of the proceeding?
Not on the basis of their sexual orientation alone, Your Honor.
Why not? I mean, why wouldn't Juror 8 be deeply offended by the sort of message projected by the defendant? I mean, that's just, I mean, if it were anything else, we would ordinarily think, that's worrisome. We wouldn't want this kind of extraneous bias to infect the proceedings. You're asking us to set that aside in the service of some other important value in the system, but I just want to know if you at least acknowledge that there is some impairment going on here of the fairness of the proceeding.
I disagree, Your Honor. I don't believe on the basis of someone's sexual orientation alone that they have any preconceived biases.
So you have a company whose CEO makes anti-gay remarks, and you're representing the company. Wholly apart from any biases, do you want a gay juror?
No, I'm not saying that that's not...
Doesn't common sense suggest that that's going to be a juror who's liable to be less favorable to you than somebody whose sexual orientation you don't know?
Yes, Your Honor, but we're asking whether they actually have the bias, and you can do that through questioning instead of making discriminatory presumptions.
What exactly are you going to ask there?
How do you feel about Chick-fil-A's owner? Have you heard about him? Do you know of his anti-gay remarks? Does that affect you in any kind of way?
Boy, that'll help.
Once you've let the cat out of the bag, I mean, the whole thing is over, it seemed to me.
Well, on page 9 and 10 of the record, the trial court judge stated that his anti-gay remarks are well known. It's not as if this would be some sort of secret.
Would you find it credible if such a juror said, no, it wouldn't bother me one bit? Really? I mean, do you think that's credible? A juror who acknowledges that she is gay, and then you proceed to question her whether or not a set of anti-gay remarks made by the opposing side would impair her, and she says, no, it wouldn't really bother me. Really? You think that measures up against common sense?
Well, Your Honor, if she said no, it would depend on how much credibility you were giving her. But at least you have the opportunity to actually examine her thoroughly instead of just making a preconceived notion on the basis of sexual orientation, which we've known since 1973 has no effect on ability. The American Psychiatric Association announced this once they took that out of the DSM.
That's just a general notion. I mean, of course, the general notion is that none of these categories of discrimination affect a person's general ability to be fair. But here we're talking about a specific circumstance. I mean, I'll give you the different example. If you use race or gender, right? If a CEO has been a CEO has been known to make anti-Muslim remarks, and you have a Muslim juror. Clearly, we don't permit the strike on that basis. But on the other hand, I mean, commonsensically, don't we think, that is worrisome? There's a different value there at stake.
It may be worrisome, Your Honor, but however, to allow a strike based on things of that nature just violates the Equal Protection Clause at the most basic level.
So your argument is really that we're serving a higher good here. We may not end up with this fairer jury, but we won't be allowing discrimination.
What I'm saying is using peremptory strikes on the basis of things that an individual cannot control that does not affect their ability is not increasing the likelihood that the jury would be fair or impartial. Because those traits that are defining of the group do not affect their ability. There must be some sort of actual questioning involved in order to determine whether the juror is not biased or is biased.
Let me ask you a basic Batson question. The Supreme Court talked about Batson applicable to folks who were historically discriminated against and who were politically powerless? The gay community has been extremely politically active in recent years and have gained substantial changes in our laws. Why should we deem them to be politically powerless now that the natural political activity, democratic activity, won't take care of this problem? Why should we impose a court rule for gay people?
Excuse me, I see my time has expired. May I briefly answer and conclude?
You may.
Because the same kind of idea was thrown around in regards to gay marriage. However, in 2012, 38 states had either constitutional or statutory bans against gay marriage. From 1999 until 2013, 33 states attempted to legalize gay marriage. 31 times it was not legalized. Just because there has been some progress does not vitiate the need for protection. And in this case, because there has been a severe recent history of limiting the rights of gay individuals, Batson's protection should be extended. And because they have not won their rights through legislative process, but rather through the judiciary, they are still politically powerless. And for the foregoing reasons, Your Honors, we respectfully request that you affirm the decision of the appellate court and remand this case for further proceedings. Thank you.
We cut into both of your rebuttal times, so I'm going to give you both the 1 minute you requested.
Your Honors, employees are not entitled to the preferred position under the ADA, to the preferred accommodation under the ADA. Thus, even if the ADA does mandate reassignment, Chick-fil-A fulfilled that obligation when it offered Ms. Sardis the administrative assistant position, a position of approximately equal status and pay, even if it was not Ms. Sardis's preferred position. Thank you, Your Honors.
Mr. Gill brought up Millerell versus Stretke. And given that Ms. Sardis has the burden to prove that Juror 8 was struck for her sexual orientation, I want to compare the evidence they had in Millerell to the evidence that Ms. Sardis has. In Millerell, they had subpoenas from former prosecutors who said it was the practice of that office to eliminate black jurors.
Millerell was an extreme case.
It was.
So that can't be the standard by which we develop a comparison for what is a Batson violation, can it? I mean, that's just the outer edge of what absolutely we should regard as a Batson violation, but there could be Batson violations well short of the outrageous evidence that was presented in Millerell.
Well, Millerell is, along with Snyder, 2 of the 3 times this court has found clear error. We're not establishing the standard for a Batson violation. We're establishing the standard for an appellate court.
Does it matter how many times we found it? Don't the courts of appeals take care of that in the routine case? It's only the extreme cases that we get that the Court of Appeals fail to correct.
That's fair, Your Honor, but the mountain of evidence you see in a case like Millerell versus and Snyder, Snyder's another one the counsel brought up where the neutral explanation was that the juror struck had work obligations. But what the court found is that other jurors who were kept on actually had more severe work and family obligations. Here we have the opposite. The juror that was struck was the juror who said the most extreme statements about fast food. Our counsel asked one question, unlike the disparate questioning in Millerell. He asked, "Have you ever eaten at one of my clients' restaurants?" This suggests an attorney who is concerned with jurors' relationship with Chick-fil-A as a restaurant, not their sexual orientation. Thank you.
Thank you, counsel. The case will be submitted and the court will stand in recess.
All rise.
So before the judges return, I'd like to take this time to announce the other awards for our program. First, I would like to recognize all of the participants in this year's Moot Court competition. As I call each individual, please come forward to receive a certificate from Professor Rasmussen, and please hold all applause until the final individual has been called from each group. Ready? It is Parsa Ansari. Please hold until there's a lot of them. Zachary Aries, CJ Bacon, Colton Cray, Deepika Dagubati, Christina Danielle, Radhesh Devendran, Cameron Edwards, Simona Ehrlich, Ian Graves, Alex Griffin.
Slow down, slow down, slow down.
No, they're sending them. Monique Matar. I'll wait now. We're a little back up. All right. I thought they'd come more slowly. I know. I'll wait for Monique to go.
Congratulations, good to see you.
Megan McDonough. Kelly McVeigh.
Congratulations.
Michael Norden. Dara O'Neill. Natasha Phillips. Sarah Pitt, who is not here today. Edward Prouty. Lisa Rubin. Danielle Stierna. Rachel Totten. Stacy Villagomez. Mark Waller. And we have Zach Aries returning.
Hey, we do it by last names, not first.
All right, Parsons going to take a picture. So please join me in giving them a round of applause. All right, we'll try to make this one a little more organized.
We're getting there.
We're going to get a hang of it by the time we get to the finalists, I think. The next participants were quarterfinalists in this year's competition. We have Kara Adams. Should I wait till they all get here? All right. I'm new to that whole MC thing. Exactly. Sujata Awasti. Adam Berger. Nicholas Cameron? Somewhere? Okay. Anna Dewan. Zachary Genduso. Jordan Kaufman. And Rachel Kim. Please join me in giving them a round of applause. Next, we have the semifinalists of this competition. We have Lauren Fishelman. Christopher Griffin. Christina Roberto. And Felipe Ruiz. Please give them a hand.
The Executive Board would like to take a moment to extend our deepest gratitude to Professor Rebecca Lonergan, whose dedication and commitment as our faculty advisor has helped make this year's Moot Court program, as with every year she's been involved, extremely successful. We appreciate your help and guidance. Thank you so much. We couldn't have done this without you. Thank you. We would also like to briefly mention USC's other Moot Court program, which is the National Moot Court Team. Each year, up to 10 students from the Hale Moot Court Honors Program are selected as 3Ls to join USC's National Moot Court Team and represent USC in competitions at venues across the country in national moot court competitions. This year's team members include Stuart Downey, Holly Farless, Kaveh Haravi, Brittany Kitchen, Daniel Marvisi, Scott Perlin, Mark Swenson, and myself. Hopefully some of the participants that you have seen before you today will join the national team and represent USC next year. Finally, the board would like to give a special thanks to USC's technology department, particularly Dave Din and Christopher Kowalski, for their help recording the earlier rounds and managing our website. and also to events, Marie Cleaves, Gemma Bustamante, and Sabrina Montes in our events department for all their help organizing today's event. Thank you.
So I now get to introduce you all to the fine people that I've been working with this entire year, the executive board. First, the first people we want to thank are the editors. They spent countless hours reading every single brief that you guys wrote and giving you meaningful feedback and really just addressing any questions that you all had and being very accessible throughout this whole process and really just being instrumental in helping facilitate practice rounds and just being advisors and contacts throughout the program. So I'd like to recognize them right now. They are Stuart Downey, who is competing in the national program right now, Amy Holbert, Michael Johnson, Lauren Collegian, Amanda McFall, and Max Rothman. Let's give them a round of applause. The next people I want to thank are the topic editors. Really, this program doesn't happen without them. The record and the bench brief were all created by them, so every argument you heard today was because of the hard work that they put in over the summer. They spent countless hours working on this record while being at big law jobs and taking just all the time out of their day to write this. So I want to thank Mary Alice DiPietro, who created the record for the ADA issue, and Holly Farless for working on the Batson issue. They're both competing at the national team right now, so let's give them a round of applause anyway. The next person I want to thank is also working at the national program or hard doing advocacy over there, and that's Mark Svensson, the advocacy chair. He was really instrumental in the advocacy part of the program. He organized all of the rounds, created the schedules, was a point of contact for anything that people had, any questions people had regarding the advocacy. So I really want to thank Mark Svensson for being just doing so much for our program. So let's give a round of applause to Mark. And then the last person I want to thank is my administrative vice chair, Amanda Sardis. She was really the backbone and glue that holds the program together. You may not see all the work that she does, but she really does so much behind the scenes, and anything that I do, it's largely because it's what she's told me to do. So without her, I would be lost. I really want to thank you, Amanda. You did so much for us, and thanks so much. Let's give a round of applause to Amanda.
Prior to the preliminary rounds of the competition that take place in November, all participants, skipped ahead. Each year we ask the students in our program to choose one participant and one board member to receive an Outstanding Service Award. This award recognizes those individuals who have contributed to the success of the program in exceptional ways. The recipients of the Outstanding Service Award were nominated by their peers in the program for showing their dedication and commitment to our program's ideals throughout the year. She has been a helpful hand to many others in preparation for argument. She has been an outstanding asset to the program, and at this time, I'd like to recognize Lauren Fischelman. And the board member selected for this award has been the organizing force behind the program. He has shown endless energy and enthusiasm preparing participants and has helped the board make key decisions throughout the year. For his outstanding contributions as a board member this year, I would like to recognize Cody DeCamp. Okay. Prior to the preliminary rounds of the competition that take place in November, all participants submit a brief for their original side and issue. The law firm of Fox Rothschild has generously sponsored the Advocacy Awards for Best Brief, which are cash awards to the 4 participants who wrote the best brief for each party on each of this year's 2 issues. LexisNexis has sponsored awards to the 2 participants who received the next highest brief scores after the best briefs on each issue, regardless of which party they represented. On behalf of the Hale Moot Court Honors Program, I am pleased to announce these awards to the following participants. For the ADA issue, the runner-up Best Brief Award goes to Adam Berger. The best, okay. The best brief for the petitioner goes to Stacy Villagomez. And the best brief for the respondent goes to one of tonight's finalists, Joseph Peacock. For the Batson issue, the runner-up Best Brief Award goes to Deepika Dagubati. The best brief for the petitioner goes to Ian Graves. And the best brief for the respondent goes to Megan McDonough. Congratulations, everyone. We are so impressed with how you did on your briefs. Now we're going to take a moment and wait for our judges to return with their decision for today's champion.
All rise. Please be seated.
The champion today will win the Edward G. Lewis Prize, a cash award endowed through a generous contribution from Edward G. Lewis, class of 1970. We would like to thank him for his generous support of our program. In addition, California Bar Brie has provided an award that will go toward a California Bar Review course for the champion of this year's competition. The three other finalists today will each receive the E. Avery Crary Award, a cash award named for the late Judge Crary. And now, it is time to announce the winners of these awards. Bailiff?
All rise. Please be seated.
I think that was what we call a photo op in the legal business.
Wasn't sure what that was.
Is it our turn to announce?
No, do we announce?
Do we announce? Does somebody else announce? Tell me what happens here. The court is in some confusion.
The court will be announcing the winner.
Uh-huh.
If you would like to either remain seated or come up here and announce the winner, either one's fine with me.
Why don't I remain seated?
That's fine.
And why don't you all remain seated? Just one prefatory remark. Unlike the Iowa primary, this was one in which some very difficult choices were involved. And none of us is entirely confident that if we sat around another 10 minutes, we wouldn't have ended up with a different order of participants because the performances were all good and they were all closely grouped. So I'm going to announce, with permission, the first runner-up and then the winner. Is that the appropriate way to do this? Yes. Okay. Our runner-up is Mr. Peacock. And the Oscar goes to Mr. O'Connor. They've asked us to make some brief remarks about the arguments in general and perhaps about each of the participants, and we are going to try to keep them brief because I know folks want to celebrate. And so why don't we start with Justice Liu?
Thank you. First of all, it's a pleasure to be here at USC. I love coming down here and being with all of you, the students, and my faculty colleagues. And you always seem to roll out the red carpet as well as manipulate the weather to be just ideal. So thank you all for the invitation. So let me say how much I enjoy doing moot court, first of all, because every time I do this, I'm reminded what immense skill all of you students have. All of you are, I'll say this very confidently, all of you are better than the median advocate in my court. That's no knock on my court. That just means that you've been vetted and you've survived many rounds that have demonstrated your excellence in getting to this point. And so it's no accident that you're better than the median lawyer in my court, because you are extremely well prepared and you've passed through many windows to get here. So I hope you will all consider a practice that enables you to continue doing what you're doing, because you're going to be very, very good at it if you just keep going. I want to make a few quick comments, and these are in the nature of observations that I've had listening to arguments in the last 5 years I've been on the bench, and try to give you some specific pieces of feedback based on what I heard today. The first thing I'll say is that a good argument is, you'll hear virtually all appellate judges say this, is in the nature of a conversation with the court. Now, that's at war with the idea of the formality and the deference and the kind of stiffness that attends this kind of proceeding. And of course, this is even more contrived because this is not a real setting. This is a moot court. But the most important thing that you can do is to put the bench at ease and to have a relaxed conversation. And that's important not just for your own comfort level, but also because it builds trust with the bench. And that's an important thing for the advocate, is to gain the trust of the bench. This is hard to do because you're students, we're judges, you feel like you have to defer to us. But the best advocates come to court ready to participate almost as a colleague with the judges. Not quite a colleague, but almost as a colleague, in a relaxed conversation that has a give and take in the way that you would discuss these issues with a group of your friends. And then everybody can sort of feel like you're talking straight and you're giving people the best answers you possibly can, and it's relaxed. So that's just something that you don't want to fall into the trap, which I think every one of you eventually did, of just kind of a staccato, I ask a question, you give the answer, I ask a question, you give the answer, I ask a question, you give the answer. That's not quite a conversation, okay? So that's something to sort of think about. The second thing is, every one of you had better arguments and worse arguments. And you have to keep in your mind which one of your arguments is the better argument and which is the worse argument, right? So just as an example, Mr. O'Connor, you had, I think, a harder argument for the broad proposition that we should just let people discriminate on the basis of sexual orientation, period. I mean, that just doesn't accord with ordinary sensibilities, I think. And so you try to give doctrinal answers, it's rational basis. And I mean, courts like law, but they also like common sense. And so, to me, at least to my sensibilities, that's your weaker argument. Your stronger argument is, on this record, who are we to second guess the trial court? You got lots of law behind you on that point, and you eventually did pivot to that point. But you could have done it sooner, and each of you could have more quickly tried to answer the harder questions about your harder position. But then once you realize that you're not getting anywhere with the court, say, even if the court is unpersuaded as to this argument, I'm going to win because I have this other argument, and move on. Because the more you dwell on the weak position, the more the court feels like your position is eroding. Last, let me say this. I think that just to underscore the point about common sense, I think that all of you as budding lawyers are being trained in the technical aspects of the law. And so you all knew the law very well, you know the doctrine and all of that. I can't tell you, though, how many times in oral argument, the argument focuses not on the law in this sort of strict technical way, but because this is a conversation, people want to understand why your position makes sense. Just at a sort of basic, fundamental, reasoning, logical, commonsensical kind of level. Save the law for the brief. That's where your technical prowess is going to show. But when you're trying to explain your position to the court, you know, we're just human beings like you are. And in the nature of things, you want to be able to persuade on the basis of the fundamental logic of your position, not because there's authority or not because there's 3 tiers of scrutiny or not because, you know, all this other legalese. So if you ever do this exercise in the future, think about how you would explain your position to either a friend who is not a lawyer, right? I mean, that's a good exercise. Or to a friend who is a lawyer but is untrained in the particular area that you're dealing with. And if you can do that, then you're going to be convincing. But congratulations to all of you. I think you all did a really fantastic job.
Judge Thompson.
Well, I would just echo a lot of the sentiments that Judge Liu just expressed to you. And I want to reiterate that when we are presented with oral arguments, we're always listening to a dispute between 2 different ideas. We're listening to one person thinks the law should be this way, and the other side thinks the law should be this way. And as we're listening to the oral arguments, we're trying to figure out, well, which one is the most persuasive? And if you can break down your argument to its simplest persuadable point and emphasize that repeatedly, try not to get distracted, but come back to what you think is the point that is the most persuasive for your position. Because that's what we're trying to do. We're trying to figure out which one makes more sense. We're also thinking about, okay, if I adopt this, what are the broader implications? So the judges are always asking the appellate attorneys, well, how would this apply in a broader context? And if you see that the judges are concerned with a broad application, that's where your emphasis should turn to, but we're not asking you to decide it broadly. You know, we're asking you to decide it narrowly. So in whatever your legal position is, you need to focus on, if there's a broad concept, what is the broadest concept that makes the most sense as it would be applied broadly? And if it's a narrow concept, you want to tell us what is the narrowest possible holding that can come out of a case based upon the particular facts of this case. But I want to just once again go back and congratulate all of you. I cannot express enough how proud I am of you. It is really not overstating it at all, but the level of advocacy that we see at these mock trial proceedings or moot court proceedings is always remarkable. I mean, we see some very bad oral arguments. We see some really bad briefs, but we see some really bad oral arguments that we leave the bench saying, now that was just a waste of time. And so as you go forward in your professional careers, you don't ever want to think that the judge, after you have sat down, is thinking that. So don't let them think that. And certainly I didn't think anything like that when each of you had performed today. So I commend you for all of the hard work and effort that you put into preparing and presenting to us this afternoon.
One of the advantages of going third is that probably everything I'm going to say has already been said. Or as I think Mo Udall once said about a debate on the House floor, everything that can be said has already been said, but not everyone has said it. So let me try to say it say it one more time. First, these were very good arguments. I think they're distinguished from a lot of the arguments we see in my court, and I saw it in my previous job, by how engaged you are in this case. You can't imagine how many times we see lawyers who, it appears, were sentenced to do the oral argument, and we'll go through it grudgingly, but you all had some passion and knowledge and vigor in this case, and you engaged with our questions. And I think that's a hallmark of a very good set of oral advocates. Let me emphasize a couple of things. One is that it is very difficult to do as a law student, and I think very few lawyers do it well, but it's difficult to be conversational, but you have to try. Because we're interested in engaging in a discussion with you about the case. Judges are pretty good about knowing the law. And if they aren't very good about it, they probably have law clerks who are pretty good about it. But that still doesn't tell you the way the case ought to come out, particularly in a case that's close. So we need to have a conversation about why, in a case that's close on two issues, we ought to choose your side rather than the other. And I think that's a conversation that occurs best at a lower key. The single best Supreme Court argument I ever saw, and I watched a year of them, and I've done a few of them, was by Archibald Cox, who, in response to a hard question, said to the court, "I was afraid you were going to ask me that question. It's the hardest question in this case, and I'm not sure I've got a really perfect answer, but here's the best I can do." By the time he finished saying the last thing, the whole bench was sort of leaning over because they were going to, he knew it was a hard question. With that, it seems to me one thing that you might want to think about in oral argument, and it's hard in moot court, is the laundry list of things you're going to do at the beginning is not very useful. Nor is the formal ending, but I assume you're required to do that. And so what I would think about in each case, a variant of what you were saying, is what's your high ground? What's your strongest point? And what's the point in which you want to return when the water starts coming up against your pants here? Andrea, your high ground is something like Barnett. The Supreme Court's looked at this once, and yeah, it was seniority, but the principle of Barnett is that companies should have a fair amount of leeway to deal with these things. Patrick, we've talked about your high point. And you can think about the other two. TJ, your high point is this is just bad stuff. It just isn't. Our courts should not be about this business. And you can and if you think about starting with that high point, saying I'm going to address the Batson issue, but the most important thing about the Batson issue in this case is either this is awful, we're keeping a citizen off a jury for an irrelevant reason, or on the other hand, we had an experienced trial judge who sat through this and she came up with the answer. Go back later to the other stuff. But if you don't start with your strong stuff, what you're going to find in oral argument is you may never get to it. A corollary of that is that occasionally judges aren't mean. Justice Liu wasn't mean. when we were saying, how are you going to tell when somebody's gay? He offered a lifeline. Grab it. Jump on it and say, "Here, you're a smart man." Yeah, maybe I was arguing, but TJ, you resisted a little bit the broader point, I think, and you were making the broader argument, and that's a good one. But he gave you a hand there, and you ought to grab it when it goes along, and you ought to be a little bit attuned to the bench's questions as an opportunity to push them in your direction, rather than an opportunity to tell the judge why he or she is wrong. Those are all difficult things, and there are lawyers that have been practicing and arguing appellate cases for 40 or 50 years, and we see a lot of them who can't do them. So it's an evolutionary process, but you guys you're among the best of the species already, so you're going to evolve very well at this. And again, so thank you all for giving us this opportunity.
Before we adjourn, I would like to thank our distinguished judges, the Honorable Andrew D. Hurwitz, the Honorable Goodwin Liu, and the Honorable O. Rosary Thompson for taking the time to preside over our final round. I would also like to congratulate all of the participants in this year's program. The program, in my opinion, has been a terrific success. And finally, on behalf of the Executive Board, I would like to thank everyone for coming to today's event. I now invite Professor Rasmussen to say a few words in closing.
Now, this is the 9th time I've got to witness the final round, and each time it leaves me with renewed respect. It relieves me with renewed respect, first of all, for the quality of our judiciary. I think you have seen today 3 great examples of people who maintain the rule of law in our country and do a great job doing that. And we're so grateful to them for being here. And secondly, it reminds me of what a great law school this really is. I'm privileged to see some people coming in as admitted students, see a few people in the contracts class. But when I see 4 people like this give that kind of performance, it really makes me proud to be part of this great school. So thank you, everyone, for renewing my faith in the law and our school. And I hope everyone enjoys the rest of the weekend. And congratulations to all 4 finalists.
We are done. No need for a gavel.